Howdy and welcome to the show. In this particular episode, we are doing our monthly deep dive into the AI world here on Cooper's Code. We have Shahrad Milanfar. Normally, we also have Marshall Cole. Marshall is heading out to trial on Monday, and so he's taken a pass. He will be joining us again next month. But without further ado, there's been a lot going on in the world of AI. We've got a few different things that we want to bring up and kind of spitball what's been happening in the AI world and how it relates to our legal world. So anything that is tickling your brain right now in terms of cool new things, changes in the law, AI bias, what have you, anywhere you want to start?
Basically, one of the things that's striking to me in terms of AI is how quickly things are changing and how quickly things are evolving, right? And so I think one of the things which might be beneficial for our listeners or viewers to talk about is what AI is and what it's likely to become and how that might impact us as practitioners in the law. When you think about it, right now, these are called large language models. And to me, that's mostly a predictive type of model, right? The model looks at what you input, and then it predicts what the words should be one after the other. And now what we're seeing is that a lot of the top AI executives are on podcasts or giving speeches talking about superintelligence, which means that this system is not only just predicting, but it's attempting to learn and become a thought process that can then change the way it responds and maybe even develop some sort of intuition that it currently doesn't have. And it'll be interesting to see how that plays out in the long run when the systems start leapfrogging their current pace of learning, and all of a sudden their way of thinking may somehow supersede what we're able to do at this point.
All throughout there as a competing theory point that came up. A friend of mine was talking about something he came across in The Economist and how with all the computing power that a few discrete individuals, so we're looking at Elon, Mark, Jeff, Sergey, acquiring massive amounts of compute. Are we just going to end up with their AI world? Meaning this superintelligence that is potentially evolving from it is being built by individuals and individuals who have their own agenda or own bias.
That's an entirely possible scenario, right? Is that these 3, 4, 5, or 10 individuals are going to have immense power because they get to tell the AI system how it learns and why certain things are important and why certain things aren't. And even now, what we're seeing is that when I ask the system to generate a picture of an attorney doing X, Y, or Z in a deposition, oftentimes it's a Caucasian male attorney doing those things. It's rare when it does it on its own, where it's a diverse person, of backgrounds that's not essentially, Caucasian or a certain age range that the system sees as the typical attorney, so to speak, right? It's when you tell it to make the attorney or the witness more diverse, that's when it comes up with something different. So right off the bat, you're looking at it, it's looking at something and saying, all right, it must be a white male attorney in this age range that does this type of work.
This is a good pivot into some of the pre-work that was done before we sat down. You sent over a fascinating article, I think by James Mixon, that was from the Daily Journal, that title "What AI Learns from Us and Why That Could Be a Legal Problem," and that starts going into some of these biases where massive overview, but the institutional biases of, say, the history of Amazon hiring then translates into how AI selects resumes because the AI sees, oh, people who look like this, white men, have been hired in the past. Therefore, the resumes we cull as AI are white men.
Right. And the thing I think it's twofold, right? It's one, how the AI is programmed to learn and respond. The other piece of it is, what responsibility do we have in our inputs to put things that might essentially level the playing field or skew it in a way that it's less of you having blinders on, I guess might be the best way to put it. And so those are two things that are important. But the question is going to be, as you talked about before we started, is if there are studies that show that our brains are more likely to get lazy with this kind of assist, are we going to take the time to do that? Or are we just going to say, you know what, just put in the basic prompt and take whatever it says? Which, like you said, there's studies out there and on neurological and otherwise that say the human brain has two segments to it, right? The reptilian brain and the higher thinking brain. And the reptilian brain is the snap judgment, and then the higher thinking brain is more lazy, but it takes more development to get an answer from it. And those are all very fascinating things to think about, but it's not something we typically do when we're doing day-to-day work, right? So we have to be very mindful of how we approach it.
So you're telling me that as you're sitting there, you're not thinking of Daniel Kahneman and thinking fast and slow, and how you're responding in the moment to various information inputs as you decide things?
Right. Only when I'm buying things incessantly online that I don't need.
Yeah.
So,
Well, as we navigate this, it feels like the kind of the next um, thinking point to cover would be the recent MIT study, Your Brain on AI, which disclosed certain things that could be concerning as one goes into meetings or one holds strategy sessions related to the use of AI. And so, for those who haven't come across the study, again, a high level overview, no real surprise, is if you have a thinking partner, your AI tool do all of your thinking for you, your brain might start not working out as hard. How do you, Shahrad, see that impacting the work that you do, the strategy sessions you may hold with your co-counsel, what have you?
it's not an easy thing to be mindful of, right? Because I think, again, as you correctly pointed out, the book Thinking Fast and Slow and Kahneman and a lot of the other studies show that if our minds have the option of doing things the easy way versus the hard way, that's what they're going to go with, the easy way. And just from my own personal development, anytime I've been pushed out of my comfort zone, I've been able to accomplish things that I never thought would be possible. Where if I'm sitting in my comfort zone, I joke with my kids that your comfort zone is a dead zone, right? You're not going to go anywhere sitting in your comfort zone. And that's something where we have to be very vigilant about it, because using AI as a crutch is a very different approach than using AI as, maybe a platform where you're bouncing ideas off of something. So again, it's not an easy thing to do, but it's almost like you got to put a post-it note on your monitor if you're going to use AI to say, hey, don't accept everything that it says, and use it as a tool, not a crutch. But it's not an easy thing to do on a daily basis for sure.
And on the accepting side, a recent uh, thing that came up in our office, um, there was an associate who was using AI as a background to digest some codes. Are there any rules about whether one needs to submit a notice of appearance in federal court if one is going to take a deposition? And Claude spat back an answer very emphatically with a uh, no, you don't need to do that. And it's based on Rule 30, subsection blank. So, associate, diligent associate, goes to that section,
Yeah.
looks at it, says nothing
Right.
that what Claude says.
Right.
And so associate, pushing back, says, you sure about that, Claude? And Claude says, oh, yeah, now looking deeper, I gave you the wrong answer. So it's interesting in the thinking partner department, if you're riffing with it as opposed to relying on it, the riff may get you to an interesting place, but the reliance has the potential of being highly troubling.
Well, but if you think about it, right? If that associate had done research, let's say on Lexis, Westlaw, or whatever platform, and come to your office and said, nah, I don't need to do that, you may have said, are you sure?
Yes.
Right? And
Yes.
this happens all the time with us and our colleagues who we work with, right? So the question is, why wouldn't somebody say that to the AI model? Because we know as a fact that the first answer is usually not as reliable as the third or fourth one. And that's where, whether or not you're being lazy or you're just saying, you know what, I don't have enough time. I'm exhausted. Let me just get through it. When in reality, what you're buying is a whole hell of a lot of trouble on the back end. Again, it's how do you treat it and whether or not you just whole cloth accept what it says, as opposed to, are you sure is a perfectly good prompt for AI, because it forces it to do a deep dive and actually give you more. I've even asked it, like, give me the sites of where you're doing this, where you're coming up with this. And I've had it, give me 3 sites. 2 of them were accurate. I checked it on Westlaw. One of them was not an accurate site. And it was like, all right, where'd you get this from? Oh, I'm so sorry, I made that up. But if the prompt also says, don't hallucinate, don't give me information that's not verifiable with a source, that helps reduce the error rate. And it's how proactive are we? Are we using it properly? If you tell an associate, hey, just go do this research for me, and you don't give them specific instructions, they're going to spend 10 hours doing the research and it's going to be totally useless to you. Same thing with a prompt. How do you utilize it in a way that's going to be more accurate? And how do you check those answers, possibly cross-platform?
I do just want to say that if you're engaging with a product, and I'm going to call it a product for the purposes of this conversation, and you have to specifically ask it not to hallucinate as part of the prompting process, that seems like a problem with the product. It seems like it should default to not hallucinating.
It should and reality are 2 different things.
Yeah.
Right.
Yeah.
And if you look at most of the AI models, at the bottom of it, it says, oh, Claude or ChatGPT makes mistakes. Make sure you're not accepting everything it said. So at the very least, they're giving you some sort of a warning, right? Even though their whole thing is, this thing is the best thing since sliced bread. Yes, it has some incredible functionality. But again, as the end user, am I doing some due diligence to make sure, knowing that it makes mistakes, right? It's not a secret that it makes mistakes. I mean, when our associates walk in the door, they don't have a label on their forehead that says humans can make mistakes. But same thing with the AI. It does have a propensity of being a people pleaser. And I think that's its biggest downfall. But again, maybe it's a good thing that they're people pleasers, considering how the intelligence is growing going forward.
Yeah. I suppose as you very quickly cross over into the dark side of people pleasing versus not people pleasing. So, although, and here we have the opportunity to go a couple different directions in terms of the conversation. Where I was thinking of going was mistakes, and maybe I'll stick with that, and then we can come back to the dark side of AI, because there was something interesting recently on that too. In the mistakes department, one of the things you brought forward, Shahrad, before we sat down was a fascinating and challenging way to deal with the potential for judicial or research attorney use of AI. Do you want to unpack that a little bit?
Sure. There was recently some news reports of a federal court judge who issued a temporary restraining order, and then the firm sent a letter pointing out to certain inaccuracies in how that order was written and attributions that were made to cases that weren't necessarily accurate. And there was no evidence at this point and no accusation that AI was used, but kind of reading into it, this suspicion is that there was a research attorney or a federal court clerk who was a law student who somehow, or postgrad, who did this research on an AI tool and then sent it to the judge who then signed that order. The court quickly corrected the order and issued a subsequent order, but it kind of, the damage is done, right? Once that order is out there. So there is that potential. The question is, as attorneys, how do we call it out if we encounter it, and do it in a way where you're not being insulting to the court, but essentially protecting your client's interest in the process?
And what I will say is the firm handled the corrections so gently that I wasn't sure why you were sending this to me as far as a conversation about AI was concerned. So with that, we've seen lawyers, from a while ago, I think this was a year and a half, 2 years ago, when the lawyer submitted briefing on the aviation 12B6 motion where the cases were completely made up, and the lawyer got in trouble for that.
Yes.
And we've seen the expert who cited non-existent items, I think actually in an AI intellectual property litigation. The irony was palpable. But when it's coming from the bench, what was your takeaway in terms of best practices on how to help the bench reach the right decision when one comes across what one might think are hallucinations or errors in AI analysis that have then infected the order?
What I thought was interesting was just the way they phrased the letter, right? It wasn't an accusation. It was basically, hey, Your Honor, there were some inconsistencies that we saw that we wanted to bring to the court's attention. It didn't ask for any specific relief. So it was done very well in that context. But the other part of it is oftentimes we get orders from the court and you read it, you get to the conclusion, did we win, did we lose? And maybe we need to double check whether or not these orders have any inaccuracies or elements that may have caused a problem, or, essentially the wrong result. And that's something that I think we've been taking for granted up to this point. And from what I've heard from judges and research attorneys is that a lot of the courts are working on AI policies, but they don't have them in place yet, which is understandable considering how quickly the space is moving.
You're causing me to click over to one of the other things that, and this was something I pulled, that the California Judicial Council adopted new AI rules. And this happened since the last time we recorded, and this talks about the use of generative AI in the state's court system, and it's not specifically on point as far as the judicial use. It's more broadly based.
Yes.
But it talks about how courts that are using AI must adopt a use policy by December 15th of 2025. There are other specific requirements related to this. Best thing to do would be to take a quick gander at this new rules. But the summary version is that the task force chose not to prohibit the use of generative AI just because it's evolving so rapidly, and that one must disclose when AI is being used to create publicly accessible content. This next piece is a common theme that I think we've seen all through time and that we will see again, that users must review and correct AI errors, including hallucinations. And this comes back to, and I think this was your statement, Shahrad, from one of our conversations in the past, that in essence, no matter who produces it, the associate, AI, a co-counsel, if you're signing it, you're responsible for it. So you better be sure it's right.
Right. And I mean, look, we're all human, right? There's no 100% accuracy on anything. But the question really is, what due diligence are you doing to reduce the potential for error? And that's something that I think from a mental standpoint can get lost because of the cognitive tendency to go for the easy route as opposed to continue to do the thing that may cause you a little bit more discomfort, but may save you time down the road.
Yeah.
The other thing that is interesting about that information that you just provided is that, all right, if the courts are creating a policy by December of 2025, what happens between now and 2025 that in terms of the AI changing? And then are these policies updated every quarter, every 6 months, every year? You know what I mean? Because what is effective today may not be effective in 6 months or a year, considering how fast things are evolving.
And that's where I think the law historically has had a hard time keeping up with technology. The law and legislatures have
Yes.
had a hard time keeping up with technology across the board. It appears that one of the learnings there is that having highly specific rules as opposed to highly specific rules don't work. Guidelines and guardrails do. So when you have comments about being responsible for what's being submitted, that's a guideline guardrail that is going to go forward, I think, forevermore, no matter who produces. Even when we have 3D generative AI counsel showing up to argue cases, if it's your generative AI associate, you're responsible for what that entity is doing.
Right. And as far as the courts are concerned, the question then is, all right, you have this AI policy in place. What do? You just give everybody access to an AI model and say, have at it? Or is there training that comes along with that to help implement and make sure that those guardrails have some cement holding them in place, right? So and that's another issue from a budgetary standpoint that the courts are going to have to face.
This goes back to your comment and bring forward the um, corrective communication to the court. As courts are allowed more access to these tools, one is going to need to read the analysis and perhaps drop it into your own AI to see if there's a hallucination there.
Right.
At least as a first round of fighting the issue.
Right. Right. Yeah, and the reality of it is, if people are stuck with, we've always used foam boards and paper, they are always susceptible to making mistakes once they jump into something like this. And it's just the matter of go slow and be methodical, and that'll help you reduce the potential for a problem.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. So I mentioned that there was a dark direction we could go with the AI piece. And I'll share with you one of, again, since the last time we recorded, one of the papers that came forward is a paper by Kenneth Payne and Baptiste Alou-Cross on strategic intelligence in large language models. And what this was they had different large language models play a variety of game theory. In essence, prisoner's dilemma for those who are familiar with that particular piece. And what they noticed is how different models took on different personalities. Google's Gemini, I guess, was considered particularly ruthless in terms of exploiting opponents and retaliating. So the takeaway here is not all AI is created equal. And I think that's something that people have started recognizing, why some people use why some people will run the same thing through multiple AI sets. I know you've been someone who, proponent might not be the right word, and I don't want to put words in your mouth.
Sure.
You were the one who brought Claude to my attention as being HIPAA and SOC 2 compliant, which for those of us who are doing work where there's confidential client information that we don't want showing up anywhere else is very important. With that as backdrop, have you been playing with other models? Have you seen different answers from different models? Are there other models that you like for different things, and why?
So one thing about Claude is that before it was very clear on their website that this is HIPAA and SOC 2 compliant. Now
Yep.
it's a little bit more murky in terms of their paperwork.
Mhm.
So it's not as clear as it used to be. So that's something to consider, and possibly, putting some safeguards around what you put in there or how you put the information in there is important. As far as other models are concerned, I've tried Chat GPT and Gemini and other models, and the real question is going to be whether or not, let's say, Claude and Chat GPT are going to have the same horsepower as Gemini has, considering the computing power that Google has, right? I mean, let's be realistic. Their servers and their computer systems are just far more powerful, resourceful, and informationful, for lack of a better description, than any of the other models. And it's going to be interesting to see how that's going to play out in the long run. But look, there is definitely a dark side, like you said, to all of this, because even just looking at it as human beings, the amount of energy these systems are sucking up, and fossil fuels aren't going to save us, with the amount of energy that we're using for running searches on these, and people just kind of do it and don't think about it. But that's definitely going to be a concern as we go along, and how these companies are going to handle that issue is going to be interesting to see.
Fossil fuels, water consumption is the other one that's been in the news a lot
Yes.
recently. In terms, I think there's a data center outside of Georgia that is consuming 500,000 gallons a day, and impacting that community's water supply and the quality of that water. And that's just one data center that opened up within the last little while.
Right. Right. And I think Meta just announced the data center that they're building. It's essentially an AI server farm, and it's going to be like close to the size of Manhattan or something like that. It's incredible what resources they're putting in, but the question is going to be to what end? And we're kind of looking at this very small sliver of AI in the legal field, but it does have wider implications that I don't think anybody really knows how it's going to play out.
It's all going to be fine. We're going to move to Mars. And actually, in a coming full circle, Elon Musk's Grok AI, is a nod to Stranger in a Strange Land, where it's a Martian. So perhaps that is where we need to go as we destroy this planet with server farms.
Right. Right. Yeah. So they really have that figured out and dialed in already. So
In the more uplifting, interesting, cool department, we talked for a second before we started about what I would describe as the category of cool new things. So, and as background, one of the coolest new things in the last year, when I do an AI presentation that I show, is the Google LM. Drop content in, and within a few minutes, it turns it into a talking head podcast where it's seamless. You can't tell that it's not human. That is something that you showed me. I actually use it as a regular research tool. When I don't have time to read all the things, I will go ahead and drop the content in, have it turn it into that podcast format so that I can listen to it while I'm
yes,
doing chores around the house. It's just phenomenal. So thank you for that.
you're welcome.
But you are the one who seems to keep bringing cool new things forward. And so that's a launch pad for what cool new thing do you have this week, Shahrad?
Let's stay on Google Notebook LM. That they've added some additional features to that, and one of them is you put, let's say you want to put a case in there, and it'll give you the overview of the case, and it's always fantastic to listen to it and then read the case, because then it becomes much more sticky. The other
Yeah.
thing that it can do is you can interact with it, right? Ask it questions that it can answer, but it also has a feature that creates mind maps within that particular chat. So it can literally break down who the parties are, what are the legal issues, what cases were cited. And so that, in my opinion, is a fascinating feature, because it's literally dicing up the information that you're putting in and giving it back to you in bite-sized pieces that's very much digestible, as opposed to you slogging through 30 pages first to try to figure out if it actually is useful or not.
And for use cases, are you using this with, say, single like Cal App case, or are you using this with like a defense's summary judgment motion? How have you played with that?
So the way I found it to be most useful to me is, let's say there was a new case that came down from the California Supreme Court, basically saying that the statute of limitations doesn't apply from the micro statute of 1 year to a person who was injured when an ambulance crashed into them. It's actually the 2 year statute, which is the right result. So that case came down, and I just took it and I dumped it into the Google Notebook LM, and it did a podcast for me, and then it broke down the various issues in the mind map section. And now I started reading the case, and it's like, oh yeah, I remember this. They talked about that on the podcast.
One of the things that we learn, and I think is important for trial lawyers in terms of communicating information, is that people have to see, hear, feel, process information typically 7 times before
Yeah.
it actually sticks. And so what I'm hearing from you is this is a great way to break the information down into component parts and just make it stickier, more digestible. I think that was your word, actually, sticky.
Absolutely. I mean, look, I'm a huge proponent of audiobooks. I used to have a very long commute when it came to going to work. So I've gone through probably 380 maybe audiobooks in my lifetime. And it's an easy way for me to learn first. And then if I read it, then it's like, oh yeah, my mind now makes the association. So to me, it's a no-brainer where if I'm taking that case, I'm putting it in there. But sometimes I'll look at it like in the audio version of that case that I was just talking about, they kept mispronouncing micra, right? So that was a clear thing that this is not perfection. I mean,
Yes. Yeah.
so it was a good reminder, but at the same time, it provides you a basic understanding of the case, and then you can read the case and flag it and highlight it and do whatever you do to make it sticky for you. But to me, if I have, 15 minutes in the car, or if I'm on a treadmill or something, it's a no-brainer to listen to that because it helps me learn better than to just jumping right in onto the case and trying to digest it and maybe having to read it 2 or 3 times to fully grasp exactly what's going on with it if I want to truly be proficient in how I talk about that case.
Fascinating. So I took us down this path. What I was trying to draw out was the some of the video work that you've
Ah,
been playing around with Google, and cool new things there.
sure. So Google has the VO3 model that they have, and basically you can go in and put information in there, and it'll essentially render a video. They're all 8 seconds videos, so you can use a particular platform. I think it's called Flow to have 8 second videos back to back if you need to. But certainly it's something new where you can put in deposition transcript, like a blurb of a question or two, and it'll render the scene and the witness, and it'll allow you to basically play that in a video. And it does it in pretty short order, like 3 to 5 minutes.
I think one of the challenges and one of the benefits of doing this program and sharing with people is it is hard to keep up with all of the cool new things that we may be able to use either as learners or as demonstrators in the cases that we're handling.
Absolutely. And that's why I love having these conversations with you and Marshall and other people. And, hopefully people who are listening or watching this, if they're doing something cool, we'd love to hear about it because all of this stuff is only limited by our imagination. And as trial lawyers, if you don't have an imagination, you better not be trying cases because nobody wants to hear boring garbage coming out of our mouths, right? So to me, if I get up in a trial and I'm not doing something that essentially captures the audience's attention, it's not a good trial. And this applies to AI as well as, well, what do you think? Can it do this? Okay, let's try it. Ask it and find out. And sometimes it doesn't do it very well and you have to tweak your prompts, but it does provide you a lot of opportunity to use your imagination to see what the possibilities are.
Yeah. I really appreciate all the things that you brought and gathered before, so we had a meaningful conversation. I'm sorry Marshall couldn't join us. I wish him, he and his client, the best of luck in their trial, and look
Yes.
forward to having them join us when we hit this session again next month.
Yeah, well,
So
thanks for organizing this and running a great conversation. I really appreciate it.
appreciate having you on. It's always
Thank you.
a pleasure, Shahrad.
Thank
So,
you.
as Shahrad said, if you have anything to share, please feel free to either drop it in the comments or reach out to at podcast@coopers.law. If you have things that you want us to cover or do a deep dive into, we'd love to incorporate things into the show. So for all of you who are listening and enjoying this, please give us a 5-star review on your favorite podcast platform of choice. Share it with a friend. And to all of you doing justice out there, happy hunting.